Okay, I'm going to call this meeting to order. It is August 30th, 2018. It's approximately 5:50 on August 30th, and we are in the Mona Lisa Drexler Assembly Chambers. Clerk, would you please call the roll?
Yes, I'd like to note for the record that Mr. Cooper, Mr. Tackey, and Mr. Gray are excused. Mr. Lejeski.
Here.
Mr. Quist.
Here.
Mr. Roberts.
Here.
Ms. Major.
Here.
Mr. Lawrence.
Here.
Ms. Dodge.
Here.
You have a quorum.
Thank you. So we're convened here this evening to sit as the Board of Adjustment for consideration of the following appeal. It is an appeal filed by Loa Hubbard. It is GR 2018-085, an appeal by Loa Hubbard of the denial of a request for affirmative recognition of legal non-conforming structure status, grandfather rights, for an existing structure with a non-conforming south front yard setback of 16.1 feet instead of the required 20 feet in the general commercial zone for the property of Tax Lot 4, Coldy Homestead, located at 208 Gaffney Road, on the north side of Gaffney Road, east of Noble Street, and north of Airport Way. The meeting at which the board deliberates and decides an appeal shall be open to the public, and a record of the hearing shall be made. Only the material contained in the appeal packet shall be considered. The board shall not hear arguments nor take additional testimony or other evidence at any time during the appeal process. The board may seek assistance from the borough attorney in the preparation of findings. Ex parte contacts are prohibited. Board members shall be impartial in all appeal matters, both in fact and appearance. No board members shall receive or otherwise engage in ex parte contacts with the appellant, other parties adversely affected by the appeal, or members of the public concerning the appeal, either before the appeal hearing or during any period of time the matter is subject to reconsideration. Ms. Dolan, do you have anything you wish to add at this point?
No, thank you.
Has any board member had any ex parte contact that needs to be disclosed or other conflicts? I see no one raising their hand. Before you are the scope of administrative review, the decisions that need to be made, remedies, and motion information. That's going to take us to discussion, but I know that Mr. Roberts would like to have a motion, make a motion. Mr. Roberts.
I move to reverse the decision of the Planning Commission and grant the appeal.
Second.
So Mr. Roberts has moved to reverse the appeal, the decision
Decision of the Planning Commission and grant the appeal.
and grant the appeal, and that was seconded by Mr. Lejeski. Mr. Roberts, would you like to speak to that?
Yes. So, reading through the packet, I think the minority members of the Planning Commission had some really good input on this. This entire project could have been done without the borough making the interpretation they did if they had taken one wall down at a time on that building and replaced it. What they did was the most efficient thing. They took one wall down all at the same time and they put it up within days. Whitaker brought that up. Brandt also brought that up. He brought up the fact that you've got the same foundation, groundwork, driveway, water, sewer, electric, placement of the facilities within that building. I think my reasoning, and I believe the real finding of fact on this is going to be, if my motion gets approved, is that we should take a broad interpretation of that word alteration. I believe that when we're interpreting it, number one, we should be interpreting as much as we can in favor of the property owner. Number two, we should interpret in favor of borough goals that we know as the assembly. We've got these goals of old buildings being replaced and things being nicer, and I won't get into all that because that's policy, but I'm sure everyone understands that concept. And third, we had a policy in place that addressed this. I believe there's enough flexibility in the word alteration that any reasonable person could easily think that that would fit within this definition based on the work that they did and how they were just replacing some walls that as it says in the packet, were heavily soaked from cigarette smoke of the past. And so it's very reasonable for them to want to replace those walls. So that's why I believe that we should grant this appeal. Thank you.
Thank you. Mr. Wojcicki is the second. Do you have anything you wish to add?
No.
Thank you. Any other discussion on the motion to reverse the appeal? Yes, Mr. Lawrence.
I'll have some discussion, also have some questions for the attorney. During the Planning Commission hearing, Ms. Nelson stated, and unfortunately, she testified that, you know, our code is written in a way that if it is not expressly stated and allowed, it can't be done. And so while our code talks about alteration or expansion, there is nothing in the grandfather rights section that talks about reconstruction, or whatever, you know, reconstruction, and I'll skip a little, reconstruction, restoration, or replacement. None of those are expressly discussed in the grandfather rights section, so the interpretation is, because it's not expressly allowed, like alteration or expansion, it cannot be done. Is that, now that was on page 17 of the record. So, Ms. Dolan, I guess that my question, you know, when I look at 18-108-040, which is the restrictions applicable to non-conforming buildings, you know, is that, I'll tell you the truth, you know, is that how, you know, our code is interpreted?
Yeah, so the way grandfather rights ordinances work generally, like if you go into treatises and how the Alaska Supreme Court has applied them, they give narrow interpretation to grandfather rights. It's not liberal construction when it comes to grandfather rights, and that's because the policy reason behind it is essentially through your comprehensive plan and your zoning code, you have set forth your policy and your standards for zoning. So when this property was rezoned, you said this property should conform to this. And we acknowledge through grandfather rights that people that can protect their investment. So it allows that structure to continue within the confines of our code. So if it's not expressly authorized in that grandfather rights provision, we don't allow it. So I think that's perhaps, I don't want to read people's minds or interpret what they were saying, but that's how our code is structured. So what we allow with respect to non-conforming structures are alterations, which we define as replace or, I just lost my train of thought. We define it specifically in alteration as the change in size or shape of the building. And so taking something down completely and demolishing it is different than altering it.
Why do you say that? I mean, what's the difference?
Well, because the whole reason you give someone grandfather rights is so they can protect their investment. Once they take it down to the foundation, they have the opportunity to comply because they're starting over. They're building new.
Well, and I don't want to get in an argument with
Yeah,
you.
and I'm not trying to debate, I'm not trying to weigh in on whether or not you should grant this, but that's the distinction between an alteration of a building, which might be maybe I'm adding a deck on, or maybe I'm doing something like that. I'm not increasing my nonconformity, but I'm altering my structure in some way. There are some zoning codes that don't allow you to do that at all. You wouldn't actually be able to even decrease your nonconformity under some zoning codes. Our zoning code allows you to do that.
All right, well, yeah, go ahead.
I want to be very clear. You said down to the foundation. Where is that and what is that based on?
I believe it's in the record that it was.
No, but you said an alteration, if you take it down to the foundation, that cannot be, that it seemed like that was part of your definition of an alteration.
Well, an alteration is a change in size and shape of a building. It's not a demolition. And so what we say is the building can continue. If the building doesn't exist anymore, it can't continue. It's gone.
All right, I've looked at this, And I understand, and I agree with the policy that non-conforming buildings and uses should not, that the restrictions on those should not be liberally construed. They should be strictly construed because for policy reasons, and I saw the footnote on the Supreme Court decision. But I know that alteration is any change in size, according to our code, is any change in size or shape of a building. And, and everybody we don't define demolition or destruction. So, one of the concerns I have is if a resident, a citizen reads our code to try to determine, and I doubt if that happened. But, as an attorney, me reading it, if a client came in and asked me, hey, can I tear down my non-conforming building to the foundation, which to me is not a total destruction at all. There's a lot of money in a foundation. And frankly, and I've seen it with my own house. The people, that burned down once, unfortunately, foundations, are reused anytime they can be because of the expense. And, if I was asked to advise a client reading the code as it reads, I don't think I'd have an answer. I don't think I would know the answer as to whether bringing down the walls and the roof falls within an alteration or the definition of alteration. And for that reason, I'm going to support this motion. From my perspective, I think a future assembly needs to add some meat to this ordinance. It won't happen during my tenure, but I think if we're going to have restrictions, you certainly want to have restrictions on how what a non-conforming building or use, what can be done, and there's got to be incidences where you lose that non-conforming. I mean, you use that grandfather right if you make too big of a change, and there's just not much here at all. But the appellant had in her brief, talked about contracts of adhesion, and I don't equate our code as a contract. But I think there is some decent analogy there. There's that, a citizen ought to be able to look at the code and know what it means. And if the code is not clear on this issue, I'm inclined to give the appellant a break. In this case, the alteration, if you want to call it, I think you can arguably say that was an alteration. The alteration resulted in less of a setback violation. And one thing one thing that kind of frustrates me is that the city granted a building permit, and one of the findings of fact is that the city didn't say anything about a zoning permit. I sure hope, and we can't take testimony, but hope Ms. Nelson and is listening, that I sure hope that when residents come to residents come to our planning department and ask for a zoning permit, and they're in the city, I sure hope they're told, yeah, you better go to the city and get a building permit. The two entities need to educate our citizens as to both requirements. I think at least let them know you better check into it. But I don't have anything more to say at this point. But at this, I'm going to be voting yes on this motion to reverse.
Thank you. Mr. Quist.
Thank you. I'd like to speak in support of the motion. I do find the argument that if the grandfather right holder has the opportunity to correct the non-compliance, then at that point, the grandfather rights would cease. But I don't see that in my reading of this record as applying in this case because of the foundation. If the foundation had been removed and starting from scratch, then there's an opportunity to correct the noncompliance, of course. But that's not, it didn't go to that extreme. And so I guess that's the long and the short of it. I would support the motion. Thank you.
Thank you, Ms. Major.
I just will agree with what many of the assembly members have already commented on, and for me, that's the idea that the foundation is still very much a part of the building itself. In fact, you really, in many cases, can't have a building without that solid foundation, and I don't even consider it would be very practicable or feasible to completely relocate a foundation, especially when we have to go as deep as we have to go in places in Alaska. So again, I think the foundation is a sticking point for me.
Mr. Lawrence.
Yeah, something I'll add is one of the problems I have is that the logic or the reasoning for arguing that the act by the appellant, was not an alteration, or that the extent of the destruction, or that the extent of the change constitutes demolition or destruction, were treatises, and it's always kind of sometimes when you're arguing before the court, you have to resort to treatises because they give you a general outline of what laws are around the country. But, it's never good when that's all you've got. And in this case, like I say, there's nothing in the code that makes it clear to our residents that what the appellant did in this case would constitute an abandonment of her grandfather rights.
Any other?
So again,
Ms. Dolan.
I don't want to weigh in at all on your decision, but I just think I'd be remiss not to point out a couple things about the law and our code. So I don't think the decision relied on treatises. I think it was an interpretation of our zoning code, and as you know, you get agency deference on that. So how this code is interpreted is how the agency applies it. But a foundation isn't included within our definition of a building. We do have a definition of a building. So I get that you're struggling with the concept that the foundation was still there and that it could be built on, but my recommendation then would be that that you propose a change to the code that either includes the foundation or includes replacing a building in the non-conforming structure portion of code. What I had raised my hand on before was I did want to make a clarification in the old policy and the memorandum that had come out of a borough attorney back in 1990, and that is they seem to confuse the concept of non-conforming uses and non-conforming structures in both the legal opinion and the policy. And so I think that was part of the confusion on whether or not alter and enlarge meant replace, was because they were thinking in the terms of a use and not necessarily a structure. And our code now, under our current grandfather rights ordinance, clearly separates out the two and has two different standards. And so I just want to make sure that when you're looking at the materials in your packet, you're putting them in context of our current code.
Mr. Lawrence, I'm sorry, Mr. Roberts, and then Ms. Major.
So, I guess I'd like to key in on what the attorney said earlier about the purpose of grandfather rights being to protect investments of those property owners, and that I agree with her that we need to fix our ordinances to make sure foundations get in there because that's a major investment. And so, maybe we don't want to go to the hole in the ground level, but when you're talking a foundation and the labor that's put in, and therefore the cost that's put into foundation, I would consider that enough of investment that, I think we have it in there already. if I remember right, for houses that burned down because we understand the expense there. And so I think moving forward, we probably will want to do something about that. But for now, I'd stand with my original reasoning on this and support this motion.
Ms. Major?
I guess if you could help me, and this is a question to Ms. Dolan. So where does our code, where does the definition of building end, right? So if the plumbing fixtures or the pipes remained as they were and were not replaced, so the walls came down, but the basics, the stuff above the foundation but below the floor, those remain, does that still constitute a part of the building?
So what our definition says, that it's the structure which supports, shelters, or encloses the property. So it includes specifically the extended structures, so the attic entries, balconies, carports, decks, exterior stairways, garages, porches, wanigans, and windows. But it doesn't address foundation, underground plumbing, things like that. I mean, it's clearly contemplating the structural support.
So I guess I just, perhaps this is where I would differ in the idea of the definition of support, right? Because the foundation certainly supports any further part of the building, right? Like you can't have a wall up without some sort of foundation. And so maybe I'm just choosing to define support, structural support in that way. But
My list seems, yes, Mr. Lawrence?
Well, I picked up on that too, but unfortunately, I mean, the definition of building, which is found, 1804-10, which is the title we're dealing with here, talks about a building means a structure for the support of persons, animals, chattel, or property of any kind. So it's not referring to that aspect of the building that provides support to the structure itself. But, the thing is, even this definition of building, I don't think I think you can argue that aspects of what was left in, after the, if we call it demolition, could still be part of the building. It's just like, like I say, the next assembly has some work to do on this issue. Because I'm not, I'm somewhat frustrated because the policy, the public policy should be to get people to conform with, with existing building codes. These building codes, especially setback requirements, have an important purpose, as far as, allowing vehicles to have vision around corners and things like that. And I presume if the applicants or the appellants had gone to the borough, they would have been told that, sorry, if you're going to do that, you're going to have to, relocate the foundation. And I guess they would have done it at that point. But as I said before, I don't see anything in this code that would have alerted me to the need of that they would be required to move, to relocate the foundation, given how far they went in tearing down the building.
Yes, Ms. Dolan?
Well, I'll just point out too that when you say there's nothing in this code that would alert them, this code requires a 20-foot setback for the general commercial zone for a front yard. So grandfather rights aren't recognized until you come in and apply for them. So you come in, you get your application, and then we affirmatively recognize those rights. So that I don't necessarily know that our code needed to put them on notice that this is how it would be applied. I'm just a little confused by that statement.
Well, I guess what I'm saying is, well, I'll be quick, but is that if I was asked to research the issue, I would have concluded they did, based upon the findings of fact, I would have concluded that before the demolition, that building did have grandfather rights. In fact, that's one of the findings that I think we need to amend somewhat, and instead of saying quite likely, I think it did. But then the question, so the point is, in taking this from the position of does it have grandfather rights, I think the facts show that it did before the demolition. And then when you, from that point on, when you read the non-conforming provisions of the code, I wouldn't have reached this, I don't think it would have been clear to me that the extent of alteration that the property owners did would have lost them their non-conforming rights or their grandfather rights.
Mr. Roberts?
So I guess I want to state for the listening public, because I'm not sure the attorney expressed this point, that while we have a process for the recognition, the affirmation of those grandfather rights, you have grandfather rights, but you don't have a piece of paper that says you have them till you come and go through the process, which is something people need more and more nowadays. But grandfather rights is something you have, but even if you haven't gone and asserted it yet, you just may have to in the future to get the piece of paper that you might need.
Any other discussion? Yes, Mr. Lajewski?
I was going to note in the definition of building in the code, at the end it says this definition does not include a fence or retaining wall. It makes me wonder if it was supposed to not include a foundation, maybe why that wasn't included too.
I think it was not included, the fence and retaining wall were included because for purposes of the setback. So you can't have a building within your setback, but you could have I'm assuming that's why it was excluded, although I'd have to check with planning. I don't know the reason behind it.
Well,
Yes, Mr. Roberts?
I think his point was that it was excluding those items, but we didn't exclude foundations when they could have been excluded along with the retaining walls and fences. And so that may give us an indication that they weren't thinking about the foundations in that way.
Yes, Ms. Major?
Just to add on to what
Mr.
Mr. Roberts just said, thank you. They went so far as to talk about extended structures and again, did not specifically call a foundation an extended structure, which could also then mean that the foundation is part of the structure itself, right?
Ooh, I think I did.
I'm
Yes,
sorry?
Ms.
Oh, sorry, no, I just thought our sound system went off. It was like a weird click. Did you not hear that? Maybe it was just
but I
me.
was engrossed by Ms. Major's
Oh,
comment.
sorry.
Any other comments or discussion? Yes, Mr. Quist?
So procedurally here, excuse me, let's say we pass this motion, are we able to do any other business here? Or does that basically end our, because I mean, we've had a couple of, implications, maybe there might be motions about amending the findings of fact or making a recommendation about further clarification of code at some point. And I get my question, I guess, is that something we want to do independently of this motion beforehand or amend this motion to do, or?
I was thinking it would be appropriate to address the motion, and then if the motion passes, to work with the clerk and the attorney to make sure she had sufficient instructions and clarity of our intent. Is that what you would recommend?
You'll have to adopt findings if this motion passes, because I don't have findings otherwise.
That would
And
be
so
after we adopt.
After you adopt
after we
this, we can draft
pass.
findings that you could then approve.
Thank you.
But as far as other future changes, that couldn't happen in the course of this
Could be an
meeting.
indication of finding of fact that we recommend future assembly address, clarify this.
That wouldn't be a finding of fact, no.
Okay.
You're finding, all
be
that's in front
stating
of
the
you
obvious.
tonight is you sitting as Board of Adjustment to decide what to do with this appeal. So that would have to be when you're in your legislative capacity as the assembly that you would address that.
Which we will not be this evening.
You will not be this evening, no.
Any other questions? We appear to be fairly ready to vote. Clerk, I believe we're ready to vote. Please call the roll. On the motion to grant the appeal is what's in front of us. A yes vote grants the appeal, a no vote votes no.
So move to the decision of the Planning Commission. Okay. Mr. Quist,
Yes.
Mr. Lojewski,
Yes.
Mr. Roberts,
Yes.
Ms. Major,
Yes.
Mr. Lawrence.
Yes.
Ms. Dodge?
Yes. Would anyone like to change their vote? Seeing none?
6-0.
The appeal has been granted and the decision of the Planning Commission has been reversed, 6-0. Now we need to move on to findings of fact. We can look at the, do we have,
If you want to maybe take
An
an
at
at
ease?
ease just till about 6:30, maybe I can draft something and then
Okay.
you can come back on and.
yes,
Okay.
Mr. Lawrence?
Well, I don't want to recreate the wheel here. I mean, there's a lot of history to this property that I find, I didn't find
findings,
anything
yeah.
inaccurate about it. So, on page 75 of the record, there were recommended fact from the department. Well, and I can't find the commission, the planning commission's findings of fact, but
We didn't address them.
what I'll say now, and we can work, what I would tend, there were 22 findings of fact, and I sure thought one of them was that, after 1970, the property may well have become a non-conforming,
At number 12,
number 12,
it says
the
with
subject parcel was
BS2.
rezoned. Became non-conforming, yeah, I know that, but there was at least an opinion is that it may very well have had grandfather rights at that point. But at any rate, it seems to me that the one finding that needs to be changed is finding number 22 on page 77, that says the changes made to the subject building in 2017 included demolition of the building to the foundation and rebuilding walls, which constitutes substantial reconstruction. I agree with all that. These changes, are considered to be an alteration of the existing building. Just take out the word not. That's kind of what I was thinking. And we can.
Oh, I'm sorry, Ms. Dolan? Yeah.
Can I maybe make a suggestion? So the Planning Commission findings are here. They're on page 50 to 51 of your packet. It was technically an appeal from the administrative hearing officer to the Planning Commission. So it says notice of decision regarding appeal of GR 2018-085. Do you see that? It's dated March 30th, 2018. My recommendation would be that you adopt their findings of fact 1 through 19 on those pages. And then not 20, 21, and 22, because I think those are specific to their decision. I would adopt a finding that says enlarge and alteration means replace if the building is reconstructed on an existing foundation, and then make a finding that the structure has legal non-conforming rights to continue.
All right,
I'm sorry, Ms. Major?
We don't have findings of fact 5 through 18 in the packet.
Oh, yeah, that's true. 50.
Oh, we're missing a page.
Yeah.
yeah, that's
We're going to
what I
go
was
grab
thinking.
the
Oh,
folder.
I'm sorry.
Hold on.
There's somewhere else in
So
here.
shall we take a brief at ease while Ms. Dolan crafts maybe a new number 20 and 21, and we get the missing page? Okay, that would be me. We have a brief at ease. Session. We are meeting as the Board of Adjustment. It's August 30, 2018. It's about 6:40, and we have just adopted a motion to grant the appeal reversing the decision of the Planning Commission, and we are at a place where we are addressing statements, findings of fact. Mr. Lawrence.
I move that we adopt the findings of fact, the first findings 1 through 19 that were of the Planning Commission, and that finding number 20 FNSB, that enlarge and alter means replace if the building is reconstructed on an existing foundation. And finding number 21, the structure has the right to continue as a legal, non-conforming structure.
Is there a second?
Second.
Thank you. So Mr. Lawrence has moved and Mr. Quist has seconded that we find the findings of fact 1 through 19 as presented on the March 30 memo from Ms. Nelson to Ms. Bingaman, Ashford Bingaman, and that we add number 20, a new number 20, enlarge and alter means replace if the building is reconstructed on an existing foundation, and 21, structure has the right to continue as a legal nonconforming structure. Discussion or debate on, yes, Ms. Major.
I would actually move to adopt the motion that's on the table, and with a look at rewording also finding of fact number 16. I don't have.
Okay. So would you like to tell us what you're thinking about on 16?
Right, so when we look at 16 right now, it states, on November 9th, 2017, the applicant obtained a building permit from the City of Fairbanks to construct a, in quotations, new commercial building on the existing foundation. The building permit states that the proposed use will be an insurance office. The City of Fairbanks did not require an FNSB zoning permit or zoning compliance letter for the reconstructed structure or the proposed new use before issuance of the building permit. So at issue for me is both the term new. So I would look at maybe saying on November 9th, 2017, the applicant obtained a building permit from the City of Fairbanks to, perhaps it would say then alter the commercial building on the existing foundation. The building, then continue to say the building permit states that the proposed use of the structure will be insurance offices. The City of Fairbanks did not require an FNSB zoning permit or zoning compliance letter for the altered structure or the proposed new use before issuance of the building permit.
Is there a second?
Second for discussion.
So it's been moved by Ms. Major and seconded by Mr. Roberts to alter our, do we need to finish?
She's
Our
amended.
first ones
No,
or
she's
not?
amended.
To amend the motion in front of us, so that number 16 would read, on November 9, 2017, the applicant obtained a building permit from the City of Fairbanks to alter the commercial building on the existing foundation. The building permit states that the proposed use of the structure will be insurance offices. The City of Fairbanks did not require a Fairbanks North Starborough zoning permit or a zoning compliance letter for the altered structure of the proposed new use or the proposed new use before issuance of the building permit. Discussion on the proposed amendment?
So at issue also seems to be the idea of this reconstruction, the term, use of the term reconstruction, and how that's applied. It's also clear from the photos that there was essentially a change in size or shape of the building. Obviously, the roof was pitched, which probably added to the interior square feet, or however it's, you know, you could argue that there's a change of the, I guess, the volume. So I'm trying to think of the right term, and it's late on a Thursday after a long week, but I just want to really make sure that we're not focusing our findings of fact do not state that it's a quote-unquote new facility, nor that it's a reconstruction, and rather an alteration on top of the foundation.
Any other discussion on the motion, the amendment to the motion? Mr. Roberts.
So, while I'm fine with the amendment because it makes it better, I actually think we could eliminate 15 and 16 because for the decision that we're making, the actions of the City of Fairbanks at this point weren't really relevant to whether they had grandfather rights at that point and what alteration means. But the amendment makes it better, so I'm fine with that.
Mr. Lawrence.
Well, I don't think the amendment makes it better, and I don't think 15 and 16 are irrelevant. I think they're part of the history of this property. And Even, I voted to reverse the commission's decision because of the language of the code. And I don't see any need of trying to rearrange the history of the building to somehow justify our decision. They did construct a new commercial building above the foundation. And, it was reconstructed and, from the ground up. So let's not pretend that didn't happen. The reason we're reversing this is because the language of the code is unclear and didn't give really doesn't give the public enough guidance for this particular situation. But the facts, from my perspective, the finding of fact in number 16 is accurate. They didn't install old materials. This is a new commercial building on the existing foundation. That's what it is.
Thank you. Any other discussion or debate on the, yes, Mr. Quist, I'm sorry, you had you down.
Thank you. So I appreciate the intent of this motion to amend. I'm a little reluctant only because the building permit that was issued by the city, which is on page 141 of the packet, is for new work. And, so I think therefore new, in quotation marks, as it is in the finding of fact, may very well be appropriate because, it's the word literally new, but then it's in quotation marks because it's the implication being that there's a different meaning in this context. So that's why I'm reluctant to adopt the motion, because this is actually a permit for new work. Thank you.
Ms. Major?
Someone show me specifically where it says new, because I'm not.
So 141 in the upper right-hand corner, there's a gray box and it says work classification new.
So what I want to be careful of is the term work classification and new, because in my world, which I understand public works, right, and work classification and new doesn't always imply new structure, new building. So I get, without knowing how the city of Fairbanks classifies or defines new, it would be hard for me to. I guess I could look it up, but work classification can have many different types of meanings.
Mr. Quist?
So my knowledge is not exhaustive, and it's been several years since I personally dealt with this, but my previous experience with the city is that this is for new work, new construction, not modification. If that's not just, it's not like a commentary on workflow, like this is a new application or something like that. It's about like that. It's new construction as opposed to, it's putting up walls instead of taking them down, and that is my understanding.
Ms. Major?
And I just want to state that in some knowledge and understanding that I have of work classification as it relates to facilities, is that not new doesn't always necessarily imply a completely new building. Without knowing the City of Fairbanks code and definition, I would hate to imply either way.
Okay, on the amendment to the motion. Any other discussion? Clerk, please call the roll. And this does not carry the main motion.
Ms. Major?
Yes.
Mr. Quist?
No.
Mr. Roberts?
Yes.
Mr. Lojeski?
No.
Mr. Lawrence?
No.
Ms. Dodge?
Yes. Would anyone like to change their vote? Seeing none?
3-3.
Fails, I believe, 3-3. Okay. Anything else in front of us? Body would allow, I would just observe that on number 15, it says that they obtained a demolition permit. I don't find that at all in our,
Couldn't find it either.
in the packet, and I find that slightly pejorative, given the situation. Motion?
I'll make a motion to, if you give me a moment to get back to the proper page. I'll make a motion to strike finding of fact number 15.
Second.
So it's been moved by Ms. Major and seconded by Mr. Roberts, I believe, to strike number 15. Do you want to speak to that, Ms. Major?
Because we don't have anything in the packet that indicates that a demolition permit was provided. It's purely speculative at this point.
Discussion on that proposed, Mr. Roberts.
So I agree with the reasoning that with it not being in the packet, and of course, as I earlier stated, I'm not sure this is relevant to the decision we've made tonight to show why we made it, which is what's important about these finding of facts. But I'm not sure that we can say it's speculative. We're just being given the word planning department, which we can take, but we certainly would like to have had the evidence in front of us so that we could examine it more closely.
Thank you. Any other discussion? Yes, Ms. Dolan.
I may recommend that you might want to keep the second sentence of finding 15 because I thought that was important in your discussion, but that's just a recommendation. You don't have to take that.
I amend the amendment to include the last sentence of 15 because I do believe that that part is important.
So 15 would read then,
The roof
the roof and the walls were subsequently removed, but the foundation remained intact.
Second.
Seconded by Mr. Lejewski, is that who I heard? Okay. Discussion on the amendment to the amendment. Is there any objection to the amendment to the amendment? Seeing none, is there objection to the proposed amendment? Yes, Mr. Lawrence.
Well, I'd like to,
Speak to it.
you know, what concerns me is that demolition permit may be in the record and we're just not recognizing it. But, you know, that finding 15 says on October 4th, 2017, the applicant obtained a demolition permit from the city of Fairbanks. I don't think the commission would have made that finding if that piece of paper wasn't somewhere. I mean, the date indicates to me that that's exactly what happened. And it doesn't degrade our decision that the portion of the building above ground, above the foundation, was demolished, because that's what happened. We saw photographs of it. So I'm not clear on the defensiveness. I mean, I don't think we need to tailor these findings of fact to somehow justify our decision.
Any other discussion, Mr. Roberts?
Well, I'd say that's part of the purpose of findings of fact, is to justify your decision in case this ends up in court and it has to be justified. But I'm not saying that it's completely necessary to strike this. I'm just fine with striking it.
Okay.
Well-
Yes, Mr. Lawrence.
Well, when I say, yeah, that part of the findings of fact is to justify your decision, but I don't think you ignore facts that don't support your decision. And that's what I want to avoid here. Or what may be inferred as not supporting our decision. I don't have any problems with the fact that there was a demolition permit issued and that demolition occurred. And I don't think we should pretend that that didn't happen.
Do you have any amendments you wish to propose? Mr. Lejewski.
Well, I just wanted to say, I thought we were removing it because we didn't know that it's a fact, because we haven't seen the evidence, not because we don't necessarily believe it didn't happen, we just don't know for sure. Do you get where I'm coming from?
Well,
It's in testimony, but you do have in your transcript, which is in your appeal record, it's your appeal record, page 13. It was during the staff report that Ms. Wassinger gave, starting on line 11. It just talks about on October 4th of 2017, the city of Fairbanks issued a demolition permit. So there was at least testimony that was given. I haven't found the permit, though.
It's not in here. Okay. Okay. Mr. Lawrence, you had your hand up.
Well, no, I mean, that, from my perspective, you know, evidence can be presented in verbally or in documentation. And just because the document, the permit, demolition permit wasn't included in the record, doesn't mean it didn't exist. In fact, this testimony would indicate that it was issued.
Yes, Mr. Roberts.
So, Mr. Lawrence actually convinced me I probably won't be voting for this amendment, but I probably would if I could remove 16 simultaneously, because I think the two go together. And so we're disrupting the timeline that we're showing with 16 by removing 15. And so I've already spoken about wanting to remove them both, but I don't want to remove just the one.
Mr. Roberts.
I would move that instead of removing, I would amend the amendment that instead of removing the entire first sentence, we remove the word demolition.
Is there a second?
Second.
Second by Ms. Major. So Mr. Roberts has moved to amend the amendment so it would read, number 15 would read, on October 4, 2017, the applicant obtained a permit from the City of Fairbanks to remove the existing building down to the foundation. The roof and the walls were subsequently removed, but the foundation remained intact. Discussion, Mr. Roberts.
So while I trust the staff giving testimony, and I think they might even be under oath at this point, I really would rather see the evidence that it's actually a demolition permit, and so I'm much more comfortable just putting that it's a permit since I can't actually see that.
Any other discussion on the proposed amendment to the amendment? Mr. Lajewski.
I'm wondering if people would feel better and if this is appropriate for a finding of fact, it was said according to testimony on October 4th, 2017.
Problem is, we're amending an amendment right now, so that
I'm
we'd
not
have
making
to.
a-
Yeah.
I'm not making a
Okay,
motion.
you're just observing or suggesting. Anything else on the amendment to the amendment?
Wait.
Yes, Mr. Lawrence. Where are we at?
Where are we? Okay.
The amendment?
First of
Uh-huh.
all, we agreed that, and we're dealing with finding number 15.
That is correct.
We've already agreed that the second sentence should remain.
Yep.
We're discussing the first sentence. And at this point, we're amending our amendment to leave in the first sentence, but take out, except for taking out the word demolition.
That is correct.
Correct?
That is correct.
Okay, well, I'd rather see the first sentence in there incomplete, the complete sentence, because I suspect very much that the word demolition probably was on that permit, and that that I don't want to sugarcoat this into saying that somehow that building wasn't demolished. It was demolished down to the foundation. And if treatises around the country indicate that most other jurisdictions would have treated that as losing your grandfather rights, maybe the future assembly definitely needs to address this ordinance, and I mean, this part of the ordinance. But like I say, I think we're kind of playing games with the facts here. I have no reason to believe that the word demolition was not on that permit from the city that was issued on October 4th. So I'll vote against the amendment to the amendment.
Any other discussion on the amendment to the amendment? Seeing none, I'm going to rule that it doesn't carry the main motion. Would you please call the roll, clerk?
Mr. Roberts.
Yes.
Mr. Lojewski.
No.
Mr. Quist.
No.
Miss Major.
Yes.
Mr. Lawrence.
No.
Miss Dodge.
Yes. Would anyone like to change their vote? Seeing none?
Three.
Thank you. The proposed amendment to the amendment failed, and we're back to the amendment in front of us, which is number 15. The roof and the walls were subsequently removed, but the foundation remained intact. Yes, Mr. Quist.
So just a point of information, City of Fairbanks building permit work classifications are sign, as in signage, new, addition, alteration, repair, move, or demolition.
Need some-
Yes,
Some clarification here.
Mr.
That last vote, maybe I might have missed,
reconsider.
So,
that this first sentence of finding number 15 has been removed?
Wait, we got somebody waving at me, somebody whispering, and somebody talking. So,
okay, sorry, let Mr. Lawrence
Thank you,
finish, and then
Ms.
if you
Lawrence.
could, let me clarify something, yeah.
Okay, procedurally, we did not, we failed to pass the proposal to remove the word demolition from the first
that's correct.
sentence. So, but we haven't voted whether to remove that first sentence or not, right? Here we are.
Okay, so the original amendment was to strike 15, and then it was amended, the amendment was amended to just keep the last sentence, and that went without objection. And then you guys amended the amendment, the one that you just voted on, was to just strike the word demolition. So now we're back to the amended amendment with keeping just the last sentence in number 15.
Boy, that was, you know,
I think you maybe didn't understand when we
no,
did
we sure
the-
didn't. I mean,
yeah.
why would, I mean, that's,
You-
I mean, and clearly other members of this assembly or this Board of Adjustment didn't recognize that either. I don't think. Given the fact that we're arguing over whether the word demolition comes out, but you're saying that it's already out anyway, and that the whole sentence is gone, right?
No. So because that amendment failed, we're not removing the word demolition. We're now back to the amendment of removing the first sentence. That's when she said it didn't carry the main motion, that took us back to talking about the whole sentence.
All right, but I thought, Ms. Dodge, you were saying that now we're just considering the second sentence, and that the first sentence has already been, we voted to remove that.
Certainly might.
That is correct.
And
So
I-
we're,
I'm with Mr. Roberts on this.
okay, so let me explain, this is what, this is what the roll call said. So the first amendment was to strike findings of facts number 15. And then a motion was made to amend the amendment to just keep the last sentence of number 15. That went without objection,
But that didn't carry the main motion either.
but it did not carry the main motion. So then we had an amendment to the amendment number 2. So that would be, I call it number 2B, which was to keep both sentences in number 15, but remove the word demolition. That failed 3-3. So once that happened, we were back to the amended amendment, which was just to keep the last sentence in number 15, and that's where we are at.
So I think you're both right. If we don't pass them, we still have this motion in front of us, the amendment, and if that fails, then 15 stays.
That's correct, Ms. Dodge.
Right.
Is that, are we
Okay.
kind of all circuitously back in the same place? Okay. So on, I think
Attorney,
on the amendment, yes. Ms. Dolan, or did,
Oh, I just wanted to caution you that you're in your quasi-judicial capacity, so you have to make your decision based on what's in the record, so we can't really consider ex parte
Oh, right, like
information,
looking it
which
up
would
on the web.
include going and doing our own research.
Okay.
So we just have
Good
to be
point.
careful on
Yeah.
that. Yeah, if it wasn't part of the record, we really shouldn't be considering it.
okay, thank you. Thanks for the gentle reminder.
Yep.
So we have before us an amendment, a proposed amendment, and ready to vote. Then the proposed amendment would,
Would eliminate the
Move the
first
first sentence.
sentence.
would eliminate the first sentence, and if it fails, then 15 remains, I believe. That's I think what we all believe we're voting on. Clerk, please call the roll. Do we need to explain anymore? Everybody understand what we're voting on?
Ms. Major?
Yes.
Mr. Wojcicki?
No.
Mr. Roberts?
yes?
Mr. Quist?
No?
Mr. Lawrence?
No.
Ms. Dodge?
No. Would anyone like to change their vote?
Yes.
Mr.
I'll
Roberts?
change my vote to a no.
Anyone else wish to change their vote? Seeing none?
1-5.
The motion fails 1-5, and 15 remains as is in front of us, or as is as part of our findings of fact. And 16 has been, so we have in front of us now items 1 through 19, with 16 having the modifications that we passed, and the addition of 20 and 21 as
Excuse
read
me.
earlier.
We did not pass any modifications in number 16.
Okay, they failed, thank you. So we have 1 through 19 as presented on the March 30 memo, and the addition of 20, new item 20 and 21. Any further discussion? Are we ready to vote on our findings of fact? I think we're ready, clerk.
Mr. Lojeski?
Yes.
Ms. Major?
No.
Mr. Roberts?
Yes.
Mr. Quist?
Yes.
Mr. Lawrence?
Yes.
Ms. Dodge?
Yes. Would anyone like to change their vote? Seeing none?
5-1.
Our findings of fact are adopted 5-1. I believe that takes us to a place where I'm going to just remind, I'll check with the borough attorney, you have everything you need?
I do, yeah.
Thank you. And before we recess, I'm going to remind ourselves that we should not have any ex parte communications about this while it's available for either reconsideration or appeal. Yes, Mr. Lawrence?
I would move for immediate reconsideration.
Oh, I was going to ask the clerk to talk about, because we're in a quasi judicial.
Yes.
We're under Robert's rules.
We're under Robert's rules, and there is no immediate reconsideration under Robert's rules. That's within your own rules when you're sitting as the assembly.
All right, thank you.
But we do need to continue to have no ex parte communication while this may be a subject of appeal or reconsideration.
What is the time frame for, I mean, reconsideration may be a day, but what's the time frame for the appeal that we need to be concerned with?
And reconsideration is at the end of this meeting, I believe.
That's correct.
So
Reconsideration
there's
must
that
happen
answer.
within this meeting.
So they have 30 days from the date that we mailed the decision to appeal to the Superior Court.
Okay.
Anything?
So I guess one question, if we've granted an appeal, is there ever a case where the litigant, for lack of a better name, would want to appeal the case they just won?
So the way our code is set up, community planning is considered a party, which means they have appeal rights. So community planning could still appeal even if the applicant didn't.
And would it just take administrative approval for them to do that, or would they need legislative approval?
They would need approval of the mayor.
Okay, thanks.
And frankly, at this point, they'd have to get conflict counsel because I advised this body, and it would be your decision that would be getting appealed, so they wouldn't be able to use my office to do that.
Mr. Lawrence?
So-
Oh, I'm sorry, Ms. Roberts.
So on this case and maybe the other case we just had that we got warned about talking on, can you let us know when the time is done so that we can speak to it if someone asks us questions? I've had people ask me questions already that I haven't been talking to, and I'm just wondering when that time ends. If you could just
Could
notify
the
us.
clerk's office perhaps calendar that and notify you? Yeah, I don't,
We can do that.
yeah.
Mr. Lawrence?
No, he asked my question.
Anything else?
Yep.
Yes, Mr. Wojciechowski.
So are the packets here public information?
Yes, those
We
are.
could
it's
give those
public
to a
record.
member of public who asks us about it, say, we can't talk about it, but here's the,
Sure.
we could do something like that. Okay.
Yeah.
Anything else for the good of the order? Seeing none, we're adjourned.